Hello guys, welcome back to another video. So friends, today I'm going to share with you about the important information on the concept of writ of mandamus. Its general meaning, its nature and scope, its objects, its conditions, or what are the grounds for approaching the High Court for the writ of mandamus, I will share with you today in this video. So before going further, please don't forget to subscribe my channel so that all videos regarding on this concept as well as other will get to you from time to time. So basically the writ of mandamus is a Latin word which means we command. Mandamus is a command or an order from the Supreme Court or the High Court to the lower court or tribunal or a public authority to perform a public or statutory duty. The writ of command is issued by the Supreme Court or High Court when any government, court, corporation or any public authority has to do a public duty but he failed to do so. Its nature and scope are basically the writ of mandamus demands some kind of activity on the part of the body or persons to whom it is addressed. So when a body omits to decide a matter which it is bound to decide, it can command it to decide the same. Where the government denies to itself a jurisdiction which it has in fact under the law, or where an authority vested with a power improperly refuses to exercise it, in that case a writ of mandamus can be issued. So what are the objects for filing the writ of mandamus is, the object of filing a writ of mandamus is to keep the public authorities within the ambit of their jurisdiction while exercising the public function. Mandamus can be issued to an authority in respect of any kind of function like administrative, legislature, quasi-judicial and judicial. So in a case where the telephone of the applicant was wrongly disconnected, although he had paid the dues regularly, but he has been disconnected wrongly, in that case the High Court issued direction to the telephone authorities to restore the connection within a week. This was held in the case of Birendra Kumar versus Union of India. So this is the general meaning, objects, nature and scope. Now we see what are the grounds or conditions for issuing a writ of mandamus. So the conditions for issuing a writ of mandamus is, the first one is there must be a legal right, because no one can claim a writ of mandamus unless he has a legal right. There must be a legally protected right before one suffering a legal grievance can claim a mandamus. So when the petitioner contended that his juniors had been promoted whereas he had been left out, his petition was dismissed because he was not qualified for the said post, because there was no legal right. Second is imperative duty. Second condition is imperative duty. Mandamus is used to enforce a duty, the performance of which is imperative and not optional and or discretionary with the public authority. It is mentioned herein, it should be mentioned herein that the writ of mandamus will not be issued where the duty is of discretionary in nature. Third condition is public duty. Mandamus is employed to enforce the performance of public duties by the public authorities, and a duty will be of a public nature if it is created by the provision of the constitution of or of any statutes or some rule of common law. Fourth condition is private duty. Generally, a mandamus would lie only to enforce a duty which is of public in nature but therefore a mandamus was not issued to enforce a duty which is private in nature and arising out of a contract between the two or three parties or any of private entity. Now, what are the grounds for issuing the writ of mandamus? The first ground is error of jurisdiction, which we have already discussed in the writ of certiorari and the writ of prohibition. Error of jurisdiction refers to such situations where the authority acts without jurisdiction, in excess of jurisdiction, or fails to exercise jurisdiction vested in it by law. And these grounds are lack of jurisdiction, excess of jurisdiction, and abuse of jurisdiction. We have already discussed these 3 points in writ of certiorari. You may see it from the playlist of administrative law. Second ground is jurisdictional facts. It is to be noted that the fact or facts upon which an administrative agency's power to act depends upon is called a jurisdictional fact. If the jurisdictional facts do not exist, the authority cannot act, and where the authority wrongfully holds or assumes that the state of jurisdictional facts exists, although actually it does not exist, and such assumption of jurisdiction is liable to be set aside or quashed by the writ of mandamus by the High Court. Third point is error of law apparent on the face of the record. And the error is apparent on the face of the record is self-evident and can be ascertained merely by looking into the records of the facts of the case. Simple. Next and last important ground is violation of the principle of natural justice. A writ of certiorari can also be issued. A writ of mandamus can also be issued when there is a violation of principles of natural justice. Now the question arises, who may apply for the writ of mandamus? The general rule is that a person whose right has been infringed may apply for the writ of mandamus. So, in a case of a company, incorporated company, the petition is required to be filed by the company itself and not by the shareholder. Where an individual applied for the enforcement of any right of an institution, he must disclose the facts to relate to as to what entitled him to make an application on behalf of that company, and such right must be subsisting on the date of filing of the petition. Now we see who may apply for mandamus. It is also required to be seen against whom writ of mandamus will not lie. A writ of mandamus will not lie and will not be issued against the president or the governor of a state for the exercise of their powers and performance of their duties. It will not lie against the state legislature to prevent from enacting a law alleged to be violative of the constitutional provisions. It will also not lie against an inferior or a ministerial office who is bound to obey the orders of the superior. So this is the writ of mandamus, which is one of the important topics of the writs under the Indian Constitution within the meaning of Article 32 and Article 226 of the Constitution of India. So friends, I hope you like this video. Please share it with others so that everyone will get the knowledge about it in very general meaning and in a very short way for examination purposes with the help of case laws, where we cover the entire procedure, object, cases, grounds, meanings, nature, scope, and all these are found in the playlist of administrative law, where you will get all the new other writs as well, like certiorari, mandamus, quo warranto, writ of habeas corpus, etc. Thanks for watching this video.